May it please your lordship.
Yes.
Your lordship, I beg to mention item 6, your lordship. Here, the legal aid counsel is not available and we have circulated adjournment petition.
All right. As prayed on behalf of the Legal Aid Council, MSM Jain, relist on
The
such and
Ghosh,
such date. Huh?
The Ghosh.
D Ghosh.
Yes, your lordship.
There has been a change.
Yes.
The legal aid.
Yes.
All right. MS D Ghosh. Huh? Your name?
SK Chakma.
By SK Chakmakul. Yes.
Deeply obliged.
Item number 4, Your Lordship.
Yes, yes. When can we
Maybe-
have it next week?
On 17th. You are leaving.
Any on 17th? All right.
Next week you are here.
Yes, yes. 17th.
17th.
Okay.
17th.
All right. As prayed to release Koediba for further hearing
As a
on
part of the
17th. Yes.
Much obliged, Your Lordship. Much.
For order item number 1.
Lordship, the connected RSA has already been admitted, Lordship.
What is this IA for?
I is for Lordship seeking
Temporary
temporary
injunction from changing the nature and character of the scheduled land.
Yes, Lordship. The
Yes. Any objection filed?
I have filed my objection, your lord.
Lordship, they are constructing a RCC structure over the Suitland, Lordship.
You want an injunction to that?
Yes, Lordship. At least status quo may be maintained, Lordship. And on
Where do you show it from?
Lordship, page number 15 of my IA, Lordship. Paragraph 11.
Yes.
Here I have stated, Lordship, categorically, that a petitioner appellant begs to state that the schedule B land, which has been more fully described in the schedule appended to this instant injunction application, is under the position of the opposite party respondents. Till date, but the opposite party respondents recently have started to construct a RCC structure over the schedule B land. Thus, the opposite party respondent is now trying to change the nature
But
and
throughout the suit, pendency of the suit, there was no stay. The respondent was in possession.
yes, Lordship, but during the title suit and during the
There are two
Title-
concurrent findings
Yeah.
and in favor of the
yes,
respondent.
Lordship.
Why should this court grant any status quo order right now? They are in possession.
they are in
throughout.
possession, Lordship, and that place is, Lordship, Suitland is situated at a marketplace, and this is besides the Assam Trunk Road and at Ronghor Sariali of Sibsagar district, and that land is fit to construct a commercial structure, Lordship, and there we are
That we
going
don't
to-
know. That you have a problem. You can always file complaints before the authorities who are giving them permission. But
Yes,
as
Lord.
far as this RSA is concerned, why should we grant any status quo right now?
Lordship,
There are two concurrent findings, and otherwise the RSA is ready for hearing.
Yes, Lordship.
Lordship.
We'll have the RSA for hearing then.
Yes, Lordship.
Lordship.
We'll have it next week anytime. We are not going ahead with the. And what is your objection to the?
Lordship, my
Where
objection.
is your objection?
Yes, I have filed it on.
R2 and respondent numbers 1 to 5.
Yes, Lordship.
Yes. What is your objection?
Lordship, in page 23, paragraph 5, I have categorically stated, Lordship,
Yes.
that the statements made in paragraph number 11 of the application, to the extent that the schedule B land is under possession of the opposite party till date is admitted. It is further stated here that the opposite party are the owners and possessors of the schedule B land, which was decided by the learned trial court and affirmed by the learned first appellate court. It is categorically stated here that the suit of the applicant was for declaring that the plaintiffs have their right, title and interest over the schedule A land. Further prayed for khas possession of the schedule B land. This particular land on which the applicant is preferring this IA, your lordship. length by
I don't
ejecting the
think there you
defendant.
have any case. I'm rejecting the IA, but I'll fix the RSA on a short
Lordship.
date.
During the title suit, pendency of title suit, and during the pendency of title appeal, there is the injunction order. That's why they could not construct. During that time, they could not construct any construction over the suit land. But now, due to in absence of any injunction order during this pendency of the regular second appeal, Lordship, they are taking advantage and started construction over the suit land, Lordship. And after going through the materials, this
There's a
honorable-
concurrent finding in support of them. Both courts have already held them as the owners
but this
and
honorable court-
possessors of the Schedule B land.
we are admitted.
Correct.
We are
That
admitting
isn't that
they are in position.
correct.
They are in
And they
position.
have been. It has already been decided in favor of them.
My humble submission, Lordship, after going through
And the recent and the recent construction of RCC structure
yes, Lord.
does not at all arises which will change the nature and character of the Schedule B land as alleged, since the suit was filed for recovery of possession of Schedule B land by evicting the defendants and by demolishing the structures, which was dismissed by learned trial court. So if tomorrow,
Lordship, if
Mr.
they-
Counsel,
yes,
if tomorrow this RSA, you suppose this ultimately the second appellate court finds that the findings of both the courts are perverse and gives it in your favor, it will be demolished if it is at their risk they are constructing.
Yes.
Sorry, they are in possession. I'm
Lordship,
disposing it off.
my humble
Miss-
submission, Lordship,
Yes, please.
after going through the contents of this application, this honorable court passed an interim order, Lordship. That may be continued, at least status quo order, Lordship. Status quo order. I am not praying for other kind of injunction, Lordship. At least status quo order, Lordship, till disposal of the RSA, Lordship. On 19/9/2025, Lordship,
But I'm disposing of the IA right now.
my humble submission, Lordship, with a direction to maintain status quo to both.
Why? Tomorrow, if you want them to be evicted, tomorrow, if you get that order, they will get evicted. If they construct something, it will be demolished. It is their risk.
That will be that.
Isn't it?
Yes,
Then
Lordship.
what irreparable loss would you suffer?
Lordship, what
You are not in possession today.
not position to die.
Then-
they have engrossed our land.
That is your allegation.
Yes,
The
Lordship.
courts, both the trial court and appellate court has held that
Yes.
they are in rightful possession. That
Thereafter,
is why you are in second appeal.
actually,
Correct.
Lordship, that second appeal has been admitted by this honorable.
Very well. Admission doesn't mean that it has been granted.
Yes.
It is only admitted. Substantial question of law has to be decided. I do not see how you will be at an irreparable loss if tomorrow this court evicts them.
Yes, Lordship.
Whatever they are constructing, that will anyway be demolished and you will,
I am agree with Lordship.
isn't it?
Yes.
So,
My
so
last
then-
humble submission, Lordship, that this matter may be taken listed.
no,
for
I'll
hearing.
dispose it of.
Yes, Lordship.
Heard Mr.
UB Sharma, Lordship.
UB Sharma, Learned Counsel, appearing for the applicant. Also heard Mr.
A.R. Shom.
A.R.
Shom.
Shom, Learned Counsel, appearing for the respondent. By filing the instant interlocutory application under Order 39, Rule 1 and 2, read with Section 151 CPC 19(8) for grant of temporary injunction, restraining the opposite party respondent herein, their men, agents, servants, employees, etc., or any one claiming under them from carrying out construction over the Schedule B land in any manner whatsoever. It is the contention of the applicant that after the
Yes.
trial court as well as first appellate court having, where are the decisions of the first appellate court and trial court?
In RSA, Lordship.
In appeal, Lordship, it page 31 starts trial court judgment.
Yes, sir. Decreed after the কি বুলি লিখিলা? After তুমি লেখা 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 as well as নকবা ঠিক আছে বাৰু as well as 1 second. You are the plaintiff.
Applicant who was.
I am the plaintiff, lordship. Suit was partly decreed.
Partly decreed,
Yes.
isn't it? Which paragraph do I find all this?
Issue number 6, your lordship, lordship will get a page 44, your lordship.
Page
Issue-
44.
Yes. Page 44, issue number 6, whether the defendants enclosed the suit length measuring 2 kata.
After the trial court Bilikova, having held that the respondent stroke defendants has not encroached the suit length measuring 2 katha 3.5 lecha from the schedule A land.
Schedule B land is part of schedule A land, lordship.
From schedule A length. that
From
is-
schedule A land.
We
Schedule
sought
B
declaration for whole schedule A land.
Correct.
Schedule 7 except schedule B land, other land was decreed in favor of us also.
And in respect of schedule B length, it was for recovery of cash possession
So
by
just
evicting.
if I say that the courts, the trial court have held that they are not encroachers of schedule A land,
B land. no,
B land,
B land.
B land corridor,
Yeah.
schedule B land corridor, which has been upheld by the first appellate court. The respondent defendant have started constructing RCC house over the said land,
Schedule B land.
over the said land. Accordingly, the instant application has been filed. Learned counsel, Mr. Nalagan, learned counsel for the applicant submits that any such construction over the schedule B land would change the nature of the land and would be prejudicial and detrimental to the interest of the applicant. On the other hand, the learned counsel for the respondent stroke defendant submits that the respondent defendant having been in possession over the schedule B land, which has already been held and affirmed by the courts, by the trial court as well as the first appellate court, any injunction restraining the respondent defendant to carry out the construction in their land would not be prejudicial, would not cause irreparable loss to the applicant, in as much as in the event this court, the second appellate court, held that the respondent defendant is an encroacher and decrease and allows the eviction thereof, any construction made over the schedule B land would automatically be demolished. Stop. Having heard the learned counsels appearing for the parties and having perused the materials available on record, it appears that the respondents stroke defendants are the owners and possessors of the schedule B land, which was decided by the learned trial court and affirmed by the learned first appellate court. The aforesaid findings of the first appellate court is pending adjudication in the second appeal, which has already been admitted to hearing. It is further apparent that the suit of the applicant was for declaring that the plaintiffs have their right, title, and interest over the schedule A land and khas possession of the schedule B land by ejecting the respondents stroke defendants and also by demolishing the boundary wall raised and a shop house and other structures constructed therein by the respondent stroke defendants. It is apparent that the said prayer was, it appears that the aforesaid prayer was already dismissed by the trial court and affirmed by the first appellate court. Be that as it may, since there is already construction of, since there are already constructed shops over the Schedule B lent by the applicant defendant, any further construction of RCC structure therein at this stage would not cause any irreparable loss to the applicant in as much as in the event ultimately in as much as the same would not change the nature and character of the Schedule B lent as contended. Full stop. It further appears that since the suit was filed for recovery of possession of Schedule B lent by evicting the defendants and by demolishing the structures thereon, in the event this court decrees in favor of the applicant, no irreparable loss and damage shall be caused to the applicant. That being so, I find no merit in the interlocutory application. Accordingly, the interlocutory application stands rejected.
Lordship,
In the yes, stay order stands vacated.
the structures and shop house was constructed by the defendant respondent, your Lordship.
I've said,
Lordship,
said.
Lordship.
Duma koislo defend shops constructed by the over the silo. I have already said it. And in the RSA is ready for hearing.
Lordship,
No, I think case record ahi sir.
LCR receipt, Lordship.
Lordship, last part of March.
So and so heard koi diba. It appears that the trial court records I say Naduta of both trial court as well as first appellate court. I got last order night court. I said records of both trial court as well as first appellate court has arrived. Matter is ready for hearing. Post for hearing in the month of.
As this honorable court fixed.
Any date in April. Yes.
In the month of April, Lordship.
All right.
Lordship,
23rd of April.
Lordship.
Highly obliged, Lordship.
Obliged, Lordship.
Mr. Lordship.
Yes, Mr. Decca, what is this IA?
Yes, my lord, on 329, my lord, during pendency of the matter, my lord, the execution proceeding has been initiated against us, my lord, and therefore, my lord, we have been filed. In this case, what happened, my lord?
For staying the execution.
Lordship,
Is this a money suit?
No, my lord, the right title interest, my lord. My lord, in this matter, my lord, on 23rd.
But stay of execution, there are so many decisions now.
My lord, best have been wanting, my lord. This honorable court on 23rd of July 25 admitted with substantial question of law record call as well as in our one IA, my lord, that is 2235, wherein for stay, my lord, issued notice was issued. But my lord, only the respondent one appeared, rest service is not complete. But suddenly, my lord, surprisingly, we received one execution notice for appearance before the Runner Trial Court, my lord. Since this matter is submitted before this court and issued notice for the stay, my lord, in the stay application, my lord, they prefer the execution proceeding. So, my lord, tomorrow is the next date fixed for our appearance, my lord. So, my lord, since this honorable court has issued notice for a stay application, in the meantime, they issued the execution proceeding.
You see, Mr. Decca, you don't. The fact of the matter is that
My lord,
there is no stay.
till now, no stay.
Correct. So
Yes.
if there is no stay, there is no prohibition for the execution court to issue notice.
Since my lord, this honorable court is stayed
No,
notice.
this court has not issued stay.
No.
Issuing a notice in the execution court, sorry, in a stay of execution case does not automatically stays the execution proceedings. Correct?
My lord.
They have the right to object in the execution.
Yes, you have a right to object there.
Then may I pray, Lord, then 2235/2025, this is our I pending, already pending. In that I am, my lord, this honorable court issues notice, my lord. So may I pray, my lord, the interim until completion of service, my
So
lord. 2235. Let's say 23rd, 7/25, this is order in the I.
this has come today for the first time.
First time, my lord. So
No,
that.
but you are appearing for whom?
I am for the plaintiff, my lord.
Sole.
Not for, my lord.
You are
Number
appearing
one.
for one. What about 2, 3, 4,
Service not
5?
complete, my lord.
Not complete.
Not complete, my lord.
Then here to little notice will go. What about that? What is the service note saying? There are total how many respondents?
Altogether, my lord, 10.
10.
10, my lord.
So 2, 3, 4, 6, 9 and 10 seems they have received. So 5 is still awaiting.
7, 8 also, my lord.
7 is awaiting. And
8 also.
8 is awaiting. Mr. Deka, what can be done?
So, my lord, since my learned friend is representing the respondent number 1 sin, and rest are yet to be service completed, my lord, since this honorable court issued notice for a stay.
Sorry, Mr. Deka.
Otherwise, my lord, my whole second appeal will be become infructuous.
You cannot be helped. The CPC makes it very clear. In fact, stay of execution proceedings are also not automatically done anymore. You have to come up with those, there are those decisions which says what kind of the scope and ambit has narrowed down.
My lord, then my.
Isn't it?
Then my, yes,
The latest
plus-
decision of the apex court has narrowed it down drastically because by now there are already all the orders in your favor, in their favor. So anyway, I'll wait up for service. Can't be helped.
my lord,
In
2235,
2235, heard Mr. P.K. Deka, Learned Counsel, appearing for the applicant, and Mr. M.J. Kadir, Learned Counsel, appearing for respondent number 1. It appears from the office note dated 5/2/2026 that service in respect of respondent numbers 2, 3, 4, 6, 9, and 10 has been served. However, none appears on their behalf on call. It further appears that service is still awaiting for respondent number 5, 7, and 8. Mr. Deka,
my lord.
5, 7, and 8 have expired or what?
Then we have to my learned friend has to submit us the details so that we could complete the legal errors.
Looks like verify. It further appears that the office note dated 19/1/2026 indicates that unserved notice of respondent numbers 5, 7, and 8 have arrived with following postal note. Quote unquote likhi diba, yate side diba office note ase. Respondent numbers 5, 7, and 8 ... within quote expired, deceased, returned to sender. এনেকে লেখা আছে তুমি ইয়াৰ পৰা দি দিবা হা So relist on such and such date for Mr. Deka to take necessary steps. You do whatever is to do, you'll have to bring them. So and just post it on another day. I will not say anything. Relist on give a date. Mr. Kadir, please find out for him. What has because the office note says, and it is not clear whether 3 of them died or.
Yes.
You also verify the party, the learned counsels appearing for the parties shall verify the same and if required do the needful in this regard.
17 of March.
And in the next IA, you issue notice and Kadir accepts for R1 for 1. Sorry.
My lord. Otherwise, my lord, if the
Execution proceedings, sorry. Next.
obliged, my lord.
Item 3,
Yes, Mr. Das.
Lordship. My senior is on legs.
Yes, yes. When can we have this matter?
Subject to your lordship's convenience, 17th of March.
17th. 17th. 17th Diva Prime, no?
within a March.
March.
Okay. As prayed for by Mr. R. Das, Learned Counsel, appearing for Mr. Chauhan also is appearing for the petitioner, repost on such and such date for further hearing.
Item 5,
Yes.
But I am not the appellant, my lord.
Second appeal.
First appeal.
First appeal. Yes.
My lord, this is a case, my lord, in nutshell. Before going into the merit, my lord, suit for specific performance of contract was allowed against me. That is, there was an agreement between me and the respondent
Suit
And-
for a specific performance.
performance of contract. Their suit was decreed. Then we prepared appeal before this honorable court. During pendency of the appeal, my lord, the land Over- The land over which suit for specific performance of contract was allowed, part of the suit land has been
disposal. That changed to it. Sorry. There is some
No, no.
difficulty today because this code will not be available in the second
Uh,
half. So I've asked them to change. There is a disposal. I'll have to sign it before leaving.
part of the
Yes.
suit land has been acquired by the government. And for the purpose of construction of flyover, my lord,
For construction of flyover.
flyover. That part has been taken over by the government,
Your land
my land.
and therefore
They are for plaintiff for suit for specific performance of contract was allowed in their favor.
there was a contract
Contract.
between you and them.
Yes.
And what was the contract?
Contract was that I will have to sell out a land measuring.
You are the seller,
I am this, yes,
the owner of the land. Yes,
Owner.
Mr. Datta?
Measuring 2 kattha.
No, just not that those details so much.
I'll
Just
come later on.
In a nutshell, I wanted to know what it is. So their land is supposed to be sold to you
Yes,
for some specific purposes.
Yes,
And for that, there were certain conditions that
Yes.
they were supposed to fulfill,
yes, yes.
right? So
Yes.
you filed a suit for
Suit.
specific performance of contract.
For-
And what was this contract about?
For
Contract
selling the land
was-
and they would get the sale permission on.
So you are a
we-
developer?
No, I am the purchaser. They are the vendor.
No, you
My lord,
will buy the land
Buy the land from
and
them
then
for residential purpose.
for residential.
My
So
lord,
they were supposed to get the permission
Permission.
for construction and
Yes,
selling
yes, yes.
those formatted. So
So
therefore,
it-
there was only an agreement to sale.
Yes,
Agreement.
Correct?
Yes.
Now you want that agreement to sale to be
performed.
Be effectuated, yes.
to be
To be
effectuated, which the trial court has
That
allowed.
was allowed.
Okay.
my lord, then now I'll enter into the merit later on. I have come up with this some decision also that during pendency of the case, when part of the land has been taken over by the government, so now this performance is practically not possible. Because we supposed to sell out land 2 kattha and odd. Now part of the suit land has been taken over by the government. So now it is not possible for the plaintiff to execute the sale deed as specifically mentioned in the agreement. Initially, when I have challenged
So
on
it
merit.
was not possible because part of the land has been taken by
Taken
the
up.
government
Yes,
for construction of flyover.
yes. Now question is the on the basis of agreement, one cannot acquire any title until and unless there was an execution of sale deed. So when this suit land was acquired by the government, at that point of time, they have no title.
Government acquired part of the land.
Part of the land,
How much?
it is nearing about
Part of the proposed sale land.
was part of the proposed sale land. I have by way of affidavit, I have brought to the
But,
notice of this honorable court.
About
Suppose,
5
see, you were already agreeable to sell the entire land, right? Now, part of the land government has acquired.
Yeah.
The remaining part can always be given to
No,
them. Why?
That is not, because as per specific performance of contract, it is a discretionary relief under section 20 of the specific relief act. This discretion is to be taken into consideration judiciously. Now that question came up in the trial court. Trial court granted them relief. Now, when the appellate stage it had come, land has been acquired during appellate stage, not earlier.
Oh, okay.
Now,
This is a
subsequent development.
Then what
Now-
happens?
In that respect, I have brought decision that if that situation arises, then they will be adequately compensated. If it is proved that we have taken money and they have given some amount, that is earnest money or advance amount, that is to be refunded with adequate compensation. That is the decision. It was kindly one
Kamalak.
my lord, 1995, 4 SCC 147, 1-page judgment. Then I will come
Yes,
up with
please.
another judgment of Karnataka High Court, where the same situation arose. 1-page judgment.
Interesting question has come.
Yeah. No, that question has, I'll ventilate it. That question has already been read.
Yes, it is settled law. Please,
It is
Mr.
settled that
Ghosh.
the agreement of sale does not confer title, and therefore agreement holder, even assuming that agreement is valid, does not acquire any title to the property. It is seen that agreement is subsequent to the notification under section so. Government is not bound by such an agreement. The inter-se dispute is only with respect to the title as on the date of notification so. The respondent is undoubted owner of the property. Here I am the owner of the property. As per section so notification, that therefore
Here, this is a case where it was for compensation. Who will get the compensation? They said that, well, we have now entered into an agreement for sale, so we should get it. But the court found that the agreement to sale is subsequent to the acquiring notification, and therefore, in that context, this was held, no, you
who
are
will
not
be
the owner.
entitled for compensation.
It
Now,
was on that.
in this case also, compensation amount has been deposited before the.
But they are not claiming that. Are they claiming the
They
compensation?
have filed objection. We
We are
are not
claiming the
getting the
They're
compensation.
claiming the land.
You are correct. You are not claiming the compensation.
And-
Are you claiming the entire land?
I'm
Because part of the
claiming
land
part
has
of the
already
land.
gone.
Yes,
Now-
regarding part of the land, what your lordship has indicated, I'm claiming the compensation. So that,
So it's twofold.
yes.
You want the land which is available.
Yes.
In addition, the compensation that is coming.
Yes, and that can be adjusted with
But
the.
the difference in the difference is that before this case in the Supreme Court, only difference is that in the present case, the agreement
Agreement was-
preceded
Yes.
the
before the-
acquiring notification.
because
Correct.
It was during filing of this appeal. that the
Correct.
government-
This notification is dated.
Which one you lordship?
Notification.
I have brought by way of additional affidavit, my lord.
So, and this is the first appeal.
This is the first appeal.
So we
That is also another question.
correct.
Whether they can raise or.
Correct. during the proceeding at that moment, this development didn't come. Now, if we will only see whether the specific performance of the contract can be validly done or not, which the trial court has done. That is the question to be decided.
Yes,
Now, suppose we find it has not been done. End of the matter.
no.
Cut. If we find that it has been
Subsequent development.
that is not relevant, Mr. Ghosh, right now.
My
Because your the difference between your case and Sunil Kumar Jain's cases,
Here in this case, I have shown only with respect
that
to
I have
who is
understood.
entitled for compensation.
You see, Mr. Ghosh, that is
Now,
all
second
right.
part.
Mr. Ghosh, it is not a question of who is entitlement. In the present issue
Yes.
case, the question of entitlement has not come. The issue before here is whether the specific performance correct.
Can be
That is
allowed.
the issue.
Yes.
Now, once that issue is decided in their favor, then the question of entitlement to the compensation will
Yes,
come.
yes.
That is consequent to the developments that has taken place. Let us understand, because these are the admitted facts. Correct, Mr. Ghosh?
Yes, yes.
This is the admitted fact. So let us concentrate on the facts of your case, because these decisions are contextual. These decisions are only contextual. There is no quarrel to the proposition that an agreement to sale will not create any right in their title in their favor. The title will have come subsequently. But the question that has to be answered is once you enter into a contract between a party to sell your land and certain conditions have been agreed between the parties, whether that can be performed or not
Performed or
performed.
not, yes.
Let us be
Now-
focused on that.
Now, kindly see the judgment that I have now given, my lord. That though it is a Karnataka High Court,
Yes.
paragraph 8, 9, learned counsel for the respondent plaintiff contended that when the land is acquired during the pendency of the suit for specific performance of contract, and if the contract could not be enforced due to acquisition of land under the Land Acquisition Act, he is still entitled to receive the compensation. It is his case that agreement of sale become unenforceable not because of any fault on his part, but because of the intervention of the land acquisition
But
proceeding.
that's not the case here.
Here it is.
That
case.
is not the case in your case. Your non-performance did not, you were not,
kindly
the
see-
performance was not debarred because of some acquisition, because acquisition
No, no.
happened subsequently.
Kindly see paragraph 9. During the pendency of the second appeal before the High Court, the state initiated proceeding for compulsory acquisition of the suit property. Paragraph 9. On the basis of it was contended before the learned lordships of the Supreme Court that the contract became incapable of specific performance in view of the fact that the subject matter of the suit itself ceased to be available, as the land was acquired during pendency of the second appeal before the High Court. It was contended that the plaintiff is not entitled to any relief. The High Court held that by acquisition of the land of the plaintiff's right do not get extinguished in totality. Totality, his right will not extinguish. And that appellate court can suitably mold the relief which the circumstances of the case may be required to permit. Incapable of being executed due to acquisition of subject land, the decree shall stand suitably substituted by a decree for realization of compensation payable in lieu thereof, as may be or have been determined under the relevant act. It was further provided that plaintiff shall have a right to recover such compensation together with the solitarium and interest due thereon. It was further provided that if the defendant had already realized the land acquisition amount, plaintiff shall have the right to recover from the defendant. So,
What does it say?
it's said that suppose during pendency of the appeal, the land was acquired and it is not practically possible to enforce the contract, because here in this case, only suit for specific performance of contract was allowed, not the compensation was. And in the suit for specific relief act, kindly see section 20, my lord, and 21. Alternative relief can be given in a specific relief act when the contract is practically impossible.
But here it's not practically impossible.
Yes, now it is practically impossible because of acquisition of the land.
No, only part has been taken.
Then part of the decree, part of the agreement cannot be, the discretion cannot be granted that yes, you do part of the decree execute and part of the decree is
No, no.
non-enforceable. Part of the contract is executable and part of the contract is
No,
non-enforceable.
for the remaining part, the compensation part will come.
Yes.
He
That
will get
part-
that compensation.
Compensation with respect to entire part, because kindly see the agreement. Cannot go beyond the agreement. In agreement,
Mr. Ghosh, today, it will take some time, I think,
yes,
this
it will
matter.
take time.
The only thing is that today this code will not be there in the second half. There is some
No,
difficulty
I have-
today. We can have it on
On any other day.
Tuesday, Thursday,
Yes.
next Tuesday, Thursday,
It will take
whenever.
time, my lord.
It is going to take time.
The matter can be part heard.
When do you want it? Thursday? Monday, this code is also not available. Tuesday, I can have it on Tuesday or Thursday.
Next week, Thursday.
Next week, Thursday?
Yes, yes.
Thursday then, Mr. Ghosh? Because it will, otherwise I'll forget.
Yes, yes.
The facts are fresh. Now, you see, Mr. Datta, you have to also
I have some judgments.
assist the
and-
code on this point.
Yes, yes, yes.
Because
The-
what is just coming to my mind is, in your case, everything happened. Now at the first appellate stage, the suit property, part of the suit property has been acquired by the government. So obviously they will not be able to
Perform.
execute that decree, because that decree is for specific performance, correct? Now specific performance is of that contract where they have to give you the entire land. Now
Yes.
they cannot give you the entire land. It
Yes.
is impossible.
Impossible.
But
Correct.
Your Lordship-
Now, in that situation, what can be done? Whether the entire contract goes or you will be adequately compensated.
That part will
I
be
think
there.
because
That
once
part
you
will
are
be there, but
compensated,
I am-
no loss is caused to you.
On that compensation, I would.
I understood.
And-
But from the court, how, because you see that decree that has been already granted in your favor
Yes,
has become obsolete now
yes, yes.
in a way.
Yes.
How can that decree be executed when government has acquired part of the land?
Yes.
That
They
is why
cannot give you
I
the
have
entire
agreed
land.
regarding compensation.
They cannot give you the entire land now. Can they give you the entire land? No. They can
So-
only give you part of the land,
Yes.
but that would be modifying the decree.
Yes, yes, yes.
So these are questions which are coming in the minds of the court. There are
I am
doubts.
Authority in
So,
that regard. Yes.
the why I'm expressing
Yes,
the
yes. So that we can-
mind of the court is that on the next date, without wastage
can
of
see-
any further time,
Yes.
you all are prepared and
Yes.
you give me what I am thinking from both sides. You apprise the court on this issues which are
For
yes.
is section 12 of specific performance of part of the contract. And that is not discretionary.
some specific performance. Can you read it slowly?
Yes. The heading is specific performance of part of the contract. Now I'll go to 12.2, where a party to a contract is unable to perform the whole of his part of it, but the part which must be left unperformed be only a small proportion to the whole in value and admits of compensation in money. The court may, at the suit of either party, direct the specific performance of so much of the contract as can be performed and award compensation in
That
money
is
for the
there.
deficiency.
That is there.
So direct.
So you get all the authorities,
Yes,
be
yes.
prepared on Thursday. I'm having it on Thursday.
Yes.
Mr. Ghosh, you also be prepared because first the points of determination in this case, perhaps this is subsequent what you are saying, but
Yes.
otherwise, if you are also contesting the
Main case.
trial court decree on merit.
Then I will have to enter into the merit.
No, in case you are also, because if you are not, then I'm not going to ask you.
Yeah. No,
So
definitely.
then you'll have
That is
to.
why I'm saying
Correct.
that
You see, both,
preliminary
no, both has to be
both has
addressed.
to be
Both has to be addressed,
adjudicated. Yes,
right?
yes.
Because in the subsequent point which you are saying, I have some reservations. I want to be more look into it. So you both assist, find whatever you get.
Another authority I'll bring regarding this new plea of fact, whether that can be brought in.
This is not a new plea, Mr. Doctor. It's
Because-
a fact which has happened.
Yes,
This is not some
No fact.
Not
fact
fact.
which was not known to them, which they have hidden, or which they
Of course,
due
that-
diligence they couldn't
yes.
find. These are not those kind of facts.
Yes.
This is something, a contingency,
Yes.
which has happened.
Then on.
Even in these cases, before the Supreme Court, it happened.
Yes.
See, and then perhaps what I am thinking is would also be some discretion of the court to see whether the decree can be executed in part. And for the remaining part, I think for that one may have to go back to that section 12
Yes.
of specific
Yes.
performance, perhaps. So you have, we'll have it on Thursday. Yeah? Heard Mr. Ghosh, Learned Counsel appearing for the appellant, also heard Mr. S. Dattana, Learned Counsel appearing for the respondent. Matter heard in part, refixed on such and such date, Thursday.
Okay.
Much more.
It will specific performance after এখন ফাইল লগত থৈ দিবচোন 12 to হেৰি কৰি 22 কৰি 12 to mark কৰি দিব না Mr. Datta, in case you have that authority of section 12, give it to the court master prior to the date fixed. You want to give any decisions or any small note, you can also give it before Thursday. Yes, whatever you want to give it, you give it. Mr. Datta, give a small note also. The idea is to dispose it on Thursday. Yes, Mr. Rathi, right?
Yes, sir.
Yes, Mr. Rathi.
May it please the Lord. My Lord, this present appeal has been filed under Section 23 of the Railway Claims Tribunal Act, impugning the judgment passed by the learned tribunal. My Lord, what has happened in this matter is, my Lord, there are more than 800 goods sheds all over the
800?
goods sheds all over the India, wherein the transportation of the goods has been going on through the Indian Railways. Now, my Lord, there has been a circular been passed, dated 5/6/2007. According to the said circular, there are 50 goods sheds which are been elevated as terminal stations, my Lord. Those 50 goods sheds shall consist of various facilities, such as train facilities, so and so forth, my Lord. My Lord, what is happening is railways are imposing terminal charges all over the India.
Terminal charges.
Yes, my lord. The entire case of terminal charges there, if your lordship might have heard previously some matter in respect to this. My lord, terminal charges are being imposed by the Indian Railways all over the India, all the station in the 50 good shed as well as other stations as well. My lord, our Honorable High Court, this question came up before our Honorable High Court, my lord, in MFA 42 and 107, two cases, my lord. Honorable single bench of our High Court has disposed the matter stating that the railway can only impose terminal charges only the given 50 stations as per the circular dated 5/6/2007. My lord, this appeal, the MFA 42 was an SLP was preferred by the Union of India before the Supreme Court. And and this matter was placed before the Honorable Chief Justice of India, consisting of 3 bench, my lord. Honorable Supreme Court has dismissed the appeal preferred by the railways, stating that there is no merit in this matter. Now, my lord, what is happening is this matter, a fresh matter. In my case, we preferred a claim before the Railway Claims Tribunal, stating the same, MFA 42 and everything we have stated. Honorable learned tribunal has stated that this judgment is itself per incuriam, declaring the
Who?
tribunal, my lord. Tribunal is declaring our Honorable High Court judgment as per incuriam, stating that it is conflicting with MFA 100 of our Honorable Court, my lord. If your lordship may, I'll just place those judgment, my lord. If your lordship may look upon
Mr. Rathi, it will take time, it looks like, no? Anyway, let me see if we can. Otherwise, the issue seems to have been decided by the Apex Court,
exactly.
because Apex Court did not interfere against the appeal filed by the railway.
Yes.
filed by
just
the
a-
railway,
Yes, my lord.
correct?
Yes, my lord.
Now, in that, the issue that was involved in that batch is whether the railway could have imposed that terminal fee,
Terminal charges.
terminal charges
Yes,
in respect of those stations which are not
in the 50 given.
in the 50 categories.
Yes.
So they have categorized the stations.
Ye-
Huh?
Yes, my lord. As per the circular dated 5/6/2007, which I've annexed at page number 89, my lord. If it won't take much consideration. my lord.
Page.
Circular starts at page number 89, my lord.
It may be taken up in another date because I have not received the Supreme Court's order, Lordship.
You have
in
not
the
received the?
Supreme Court, Honorable Supreme Court order, Lordship, whether it is decided on merit or something else.
All right, then you give her the copy.
My
And
lord,
do you
it's
have the
one
copy of
statement.
do you have the copies of the other papers?
Yeah.
Do you have the copy of the High Court judges
I've
judgments? So you have a look at it. I'll have it fixed on Thursday.
That's it.
Because according to them, the matter has already attained finality in the other case. So you find out whether this the issue here is also squarely covered, because the tribunal is saying that the order of the Guwahati bench, Guwahati High Court is per incurium. Now, on what basis the tribunal is saying that? So whether those judgments are per incurium or not, these are very important issues which will have to be decided ultimately by this court.
Yes.
So you find out, and also both of you come up on that day with those decisions of per incurium.
Yes, my lord. I have those judgments today.
Get it?
My lord, there's just
Anyway.
one thing I wanted to point out, my lord, in this matter. If your lordship may look upon the order dated 11 December 2025.
Mhm.
Honorable Court directed my learned senior friend to obtain instruction on December, my lord, 11 December.
Mhm.
If your lordship may.
These instructions of?
Instruction as to satisfying why this judgment, how can this judgment be declared as per incurium?
Yes, you do it, whatever is to be done,
Yes,
keeping in mind the Supreme Court's this order that is given to you. Heard Mr. D. Rathi, Learned Counsel, appearing for the petition appellant, and R. Devi, Learned CGC, for the respondent. Mr. So and MS Devi seeks a short accommodation to obtain the instructions as was sought for by earlier by this court on 11/12/2025. A copy of the apex court judgment affirming the coordinate bench's judgment rendered by this court in FFA number 42 of 2017
Yes.
is also furnished to MS Devi for giving her response in this regard.
And MFA 105 2007. Two cases, my lord, identical. Similar.
This is not mentioned here. That is mentioned in the Supreme Court decision. Give a
No,
Yes, my
copy.
lord. I've given to my.
Okay, you just give that citation. Huh?
Yes, ma'am.
That Supreme Court judgment affirms two of the coordinate bench or one, Ms. Devi?
Of 2017.
Both, my lord,
Yeah, ठीक है.
I
Anyway, that we will see
That-
here. Let it put
Yes,
42
absolutely.
because that says 42, the order. That you keep it. We no need to give it right now. Relist next week. Na lage basic matters. Tar pisar we got detail.
I'm much obliged.
This is an arbitration appeal.
Yes, Lordship, PCR was called.
You are appearing for whom?
In person, from a respondent lordship.
For respondent.
Lordship.
But there was a counsel representing you
He was-
earlier.
He was present earlier, now he has taken the government job. This,
You do not want to engage
No,
anyone?
I'm earlier in that court below, I'm attending it. Before High Court also, I'm attending so many cases, lordship.
You are comfortable
Lordship,
conducting the
by
case?
grace of God, it is. like-
No, I don't have any problem. I'm asked because you will have to keep coming.
Yes,
That is why.
I'm-
Keeping your comfort in mind, I asked. And in
I-
case if you want that this court provides an amicus curiae for you, this court can do it. If you want, I can appoint an amicus to assist you also. Do you want any amicus curiae?
No, thank you.
You are sure?
I'll do.
What is this appeal?
Lordship, this is for dispute of sole arbiter, Lordship. And PCR was called, Lordship, on last.
This year, Ahisa?
No, Lordship.
Oh, so we'll have to wait for the records.
Lordship, one submission is there, sir. And just a brief one. This matter is of the year nineteen
Mr.
ninety-two.
Your name?
Ghanshyam Das
Mr.
Dhiman.
Ghansam?
Das Dhiman.
Mr. Ghanshyam Das Dhima.
Dhiman.
Dhiman.
Yes.
Mr.
and-
Dhiman, you see, there are certain procedures that this court has to also apply. That is why I asked if you want an amicus curiae to be assisted, because he would have been able to explain to you all this. Now, the records would be available for a final for considering the appeal for final adjudication. Without the records, it will not be possible. How I'm going to issue a reminder, try and get it as fast as we can. Unless the records come, this court can, this proceedings cannot proceed. Please try and understand. I have understood you want to, you have some anxiety in your mind. You want an early disposal. I appreciate it. But you see, unless the records come, it will be difficult. All right.
One fact I want to draw.
Yes.
One small fact.
Yes.
This case has already been decided by Honorable Supreme Court
Yes.
on 3 January 2000. In spite of that, they are coming before the lower court for continuation of delay.
Mr. Dhiman, please refrain from using the term lower court.
Sorry,
They are
court
trial
below-
courts.
court-
They are not court below.
No,
No,
not
no.
I'm talking about this
Trial-
district
District court, right?
District court,
So
district
they are trial courts.
trial court.
They
Sorry,
are trial courts or district judiciary is not a lower judiciary. The time has changed, and with time we must also change.
I'm sorry.
No, it's all right. Sometime by mistake it keeps coming, but this is something consciously we are trying to refrain from using.
Lordship, one permission will be allowed.
Yes.
They are not, because earlier they have, Honorable Court has given time for bringing of that record.
You see, Mr. Counsel, the case records are not going to be brought by them. It has to be brought by the registry. So you please bear with the court, and if needed, I may give you an amicus curiae. I am giving you that option again, because otherwise it becomes very difficult for the court to communicate with the litigants. Because you see, you may not be understanding the procedures in the court. Final hearing, you want to argue, it is okay. But if you have an assistant, it will be easier for you.
Lordship, one thing it can be done if Honorable Court or instruct me, I can bring the record from that area.
That it doesn't happen like that. Heard Ms. MS
P. Radha on behalf of Ms. A. Gayan.
P. Rabha,
P. Radha.
Learned Counsel appearing on behalf of MS A. Gayan, Learned CJC,
Yes.
appearing for the appellant. Also her ticker naam to pala, Mr. Dhiman. Ghanshyam
Das Dhiman.
Das Dhiman, etu likhi lok spelling to bhul hobo na lage eko. Who appears in person for the respondent, in person. It appears that the case records called for earlier by this court by order dated 8/1/2026 is yet to arrive. Let scan copy bilikwa. Let the registry obtain the scan copy of the TCR immediately on a priority basis. I'll give a small date because the scan copy. They can, why is the registry taking so much time? It follow korai loba. It's a scan copy. Scan copy can come through the email. So we'll have it on next week to Bahut matters also. RP survey.
Today I am used to coming from Chandigarh.
You have come from Chandigarh?
Chandigarh. I'm having this flight. So today I'm arriving for this case.
That is why I was giving you an amicus curiae. You do not even want that. You can appear through virtual mode. You don't even want to utilize all that.
Lordship, I have
give a date.
in next week, Lordship.
You see, Mr. Dhiman, what if next week the matters the records doesn't come? You will be again prejudiced. I am giving it after that week so that there will be sufficient time for the records to come. There is a judicial order calling for the record. You have to understand.
Kindly fix a date.
Yeah, I'm giving you a date, Mr. Dhiman. I'm conscious that you are appearing in person. I am, in fact, to help you and assist you. This court is offering you to appoint an amicus. You do not want to take that assistance. So, 26th of February. Difficult?
Of this month?
Yes.
Ah,
Any difficulty?
So difficult, I have to stay here, so I'm going in Tezpur also.
No, if you want on another date, we'll postpone it. You want it in
but
March.
No, in this month only.
So 26.
26th. Obliged Lordship.
And nowadays you can appear in a virtual mode. Virtual mode is available.
That is, but
Yes.
my old house is in Tezpur.
So that is your convenience, Mr. Mr. Dhiman. So please do not show the air ticket to this court unnecessarily. You have a. It's all right.
I'm saying.
Yes. Any other?
Obliged Lordship.
Yes.
Obliged.
कोई बोल